All right, hi, Attorney Steve Vondran back. We are back with the final. Well, that's not the final. I have one. I have a video on rights of publicity, so I'm not going to do another video on that. You have that, but this is going to be the final three of the four privacy torts in California. We already talked about intrusion on seclusion and solitude. We talked about putting someone in a false light. Now we are going to talk about public disclosure of private facts. And again, I already have a video on right of publicity, which is the fourth privacy tort in California. So let's talk about public disclosure of private facts, and let's head right here to CACI 1801 jury instructions. Okay, so these are the jury instructions that a jury would consider if they heard a case. In other words, as a plaintiff, if you're bringing a case like this, you want to be able to name all these elements. You need to be able to make the allegations for each element. You need to be able to prove each element, okay? If you're the defendant, you need to poke a hole in one of these elements to basically prevent the tort from succeeding in court, okay? So this one is publication or disclosure of private facts. So this is a case where somebody goes on the internet and they're posting your intimate life details, things that may be very secretive to you, that don't have a newsworthy value to it, maybe saying, well, this person has herpes or something, and you're saying like, well, why do you have to tell people that? They have to deal with that. It's not public newsworthiness. It's not something people want to know. And that's just giving you an example, but it would be anything that is a public disclosure of something that most people would consider to be private. So let's take a look at here what a plaintiff needs to prove. Plaintiff claims that defendant violated his or her right to privacy. To establish his claim, plaintiff must prove all of the following. Must prove all the following. If you can't prove one of these, you fail, your case loses, okay? That defendant publicized private information concerning the plaintiff. So that's two things. Publicized, that means there was some sort of publication. So, there's a good amount of people that could actually read and access it and go, oh my gosh, look at that. Look at that. So publicizing private information, there's actually three things. Private information, something somebody would actually take efforts to keep private and would want private concerning the plaintiff. So it has to be publicized, private information, and concerning the plaintiff. Okay, so you weave your facts into this and you start talking about how your facts satisfy this, you make those allegations in your complaint. Two, that a reasonable person in plaintiff's position would have considered the publicity highly offensive. So this goes back to something we have in law, the reasonable person standard. What does the reasonable person do? That's an objective standard, okay? That means, well, you sitting there as 12 jurors, what would a reasonable person have done? Would a reasonable person have flipped their lid and said, oh my God, that's highly objectionable. I can't believe someone's doing this. That is the question that you need to be able to prove, okay? Number three, that the defendant knew or acted with reckless disregard of a fact that a reasonable person in plaintiff's position would consider the publicity highly offensive. So they knew or were acting in reckless disregard that the person would consider it highly offensive. You need to be able to allege that, and it can be hard. How can you prove they knew something, their state of mind? How can you prove they knew it? Many times you're going to be looking at acted with reckless disregard of the fact, just didn't care, like just boom, a bull in a china shop, just who cares, that kind of thing. Four, that the private information was not of legitimate public concern or did not have a substantial connection to a matter of legitimate public concern. This is where the First Amendment comes in, free speech. We've talked about in the other torts where free speech is going to play a part of these things, like right of publicity. Is it a news article? Is it, if it's disclosure, intrusion on seclusion, is this a world famous athlete that's down at the beach? Do they get that privacy? Those kinds of things. So the plaintiff needs to show, this is important, the burden is going to be on the plaintiff in California anyway, and your state may have different rules. They may not have this tort at all. This may not be a tort in your state. But in California, Arizona, where I practice, in California in particular, this is the law in California, okay? So you need to show that it's not a legitimate public concern, and this is where big fights can happen. You say, well, look, it's newsworthy. Look, if I told you, you would say, wow, that's interesting, wouldn't you? If I told you this person had a 780 FICO score because I put their credit report on the internet, would that be newsworthy? I don't know, so these are the things that you can end up arguing about. Plaintiff needs to show, number 5, plaintiff was harmed, and that the defendant's conduct was a substantial factor in causing the plaintiff's harm. So again, you may have multiple defendants. You need to show each one as a substantial factor. So just name the ones that you know are a substantial factor. And here, this goes to that important question. Let's highlight that right here. In deciding whether the information was a matter of legitimate public concern, you should consider, among other factors, the following. 1, the social value of the information. Was there any social value in knowing somebody has a 780 FICO score or a 450 FICO score or herpes? I mean, are these things that people really need to know? Is there any social value to that? Not really. The extent of the intrusion into plaintiff's privacy, like to what extent, maybe somebody's going through a divorce and the ex-spouse is throwing all kinds of things out on the internet, and here's his tax returns, here's a letter he wrote to me, here's a text message he wrote to someone else, totally using bad words, and that kind of stuff. Is it really a matter of public concern? What kind of intrusion is it causing? What type of offensiveness and embarrassment is it causing? Number C, subsection C, whether the plaintiff consented to the publicity. Consent can be a defense. By voluntarily seeking public attention or public office. Again, this is your public figures, and this comes out a lot in these privacy torts. Again, weighing First Amendment versus publicity, public figures, public officials, sports stars. These people are famous. They make money because of their fame. They sort of need the press. No press is bad press, right? So to what extent do they consent by the mere nature of their stardom to publicity? You can't just say, hey, I love the publicity. Not today, not today, not today. So there's going to be that little tension that's going on in these types of cases, and any other applicable factors. So that is and there's one other little ditty there. That's just publication. Make sure it's public to enough people so many people know that the information was substantially certain to become public knowledge. Okay, so that's one final little thing. But anyway, that is in a nutshell. That's California law. Again, California, your state may be different. But these are, we have discussed now, the 4 torts, the 4 privacy torts in California. Intrusion on seclusion and solitude, which is the public affairs. We hit the false light, which is very similar to defamation. We hit publication of private facts. These are non-news facts, just private things. And again, these things are objectionable to a reasonable person. The First Amendment is normally going to play some kind of role in these kinds of torts. And the final one is the misappropriation of the use of another person's name, image, or likeness. That's right of publicity. I have another video that's already out on that. Realize the right of publicity applies to everyone. You do not have to be a superstar to have a right of publicity in California. So if you need help with any of these torts, somebody's violating your rights, somebody's claiming you're violating their rights, we help plaintiffs and defendants in arbitration, litigation, mediation matters involving internet law, right of privacy, entertainment law, and copyright intellectual property law. Okay, so that's about it. I hope you like this video. Go ahead and subscribe if you like it. We're over 10,000 subscribers now, so people are loving our channel, but make sure you hit that little bell so you can get in and get some future videos when we're launching them. So this is Attorney Steve. You can find me on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Have a great weekend, Super Bowl weekend. I'm done for the week, so have fun. We'll catch you probably on Monday. Okay? Have a great day now.